Oyez, oyez, oyez. All persons having business before the Honorable United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-1479, Daikin Applied Americas, Inc. and Super Radiator Coils petitioners versus the EPA. Mr. Rogers for petitioners, Mr. McDermott for respondent.
Good morning, counsel. Mr. Rogers, please proceed when you're ready.
Good morning, Your Honor. My name is Charles Rogers. I'm present today arguing on behalf of Daikin Applied Americas, Inc. and Super Radiator Coils, LLP. The issue before this court is whether the final rule providing for the listing of the Highway 100 County Road 3 site is arbitrary and capricious and contrary to law because the EPA did not establish with substantial evidence that the underlying aquifers are interconnected. The theory of the EPA is expressed in very succinct terms in their brief on court docket 31, otherwise page 22 of the brief, the first paragraph. There they make it clear that their theory is that chemicals have been released or were released over the years from the surface and made their way through an underlying very shallow drift aquifer, which is immediately under and adjacent to a site that the petitioners are presently investigating and remediating. And that thereafter, the contamination made its way through successive lower aquifers, then through a confining bed, an aquitard called the St. Peter aquitard, down to the Prairie du Chien. The duty of the EPA in this regard is outlined in 40 CFR Part 300 App A. The EPA is duty bound to provide substantial evidence and a rational scientific explanation establishing connectivity. That is their burden. There can be no presumption of connectivity. And as this court made clear in genuine parts, where there is a confining unit or an aquitard between two aquifers, there is no connectivity. The hazardous ranking manual, 50 Fed Reg 55,553, outlines 4 general methodologies that the EPA is to employ in establishing a connection between the underlying aquifers. First, they should present the court and the petitioners with borings establishing that there is no connection, or that there is a connection between the aquifers that are relevant to the site. Here, the EPA has presented the court and petitioners with no borings within the confines of the site establishing connectivity. If I could address the court to a diagram that is on court docket 49 of petitioner's
Mr.
open
Rogers,
brief.
I can just interject, ask a clarifying question. In this case, there isn't any dispute that there are contaminants in both layers that you say are separated by an aquitard, and the EPA doesn't accept that. There are contaminants in the both aquifers. Is that right?
That's correct, Your Honor. There are contaminants in all 4 aquifers that are the subject of this dispute. The theory, though, Your Honor, is that they have to show is that just because there's contamination in all 4 aquifers, you can't presume that they're interconnected. You have to show that the interconnection either with borings showing that since there's a confining unit, that the confining unit is not continuous throughout the site, or you have to show pump tests.
Right? The reason it would matter whether or not they're interconnected is whether the connection somehow artificially inflates the scoring so that it becomes a priority for listing. But I don't need you to have proposed how one would look at sort of 2 separate sites and describe them as below the threshold for scoring. So, I mean, you can see that there is contamination under the surface, and that's, as I read EPA, that's all they're saying. They're not making a conclusion about where it comes from. They're not making a conclusion about any particular source of it. They're just saying, look, this is a problem, and it's a problem for a large number of people, and it's a risky enough kind of contaminant that the EPA has an obligation to investigate further. And what
Your Honor, I don't think,
dispute?
sorry.
Oh, go
I'm
ahead.
sorry,
I'm
cut you
sorry.
off.
No, it's just a little delay.
Sure. If you could look at page 16 of the petitioner's opening brief. This provides an overview of the description of the site provided by the EPA. Here we see that the description of the site is a small triangle immediately under and adjacent in the drift aquifer to the petitioner's, a site that the petitioners are presently investigating and remediating. If this court were to find...
I'm sorry, Mr. Rogers, which page? 16
I'm sorry,
just
court
has...
docket. I'm sorry, I'm looking at page 8 and court docket 16 of our brief, petitioner's brief.
Which is a diagram.
Correct.
Is that what you're referring
That's
to?
right. That's what I'm referring to. I'm sorry. And that diagram makes it very clear, I'm sorry, that they have put a bullseye on the site by which that both Daikin applied and super radiator coils are remediating. If this court were to find that there is connectivity.
That's not EPA's diagram. That's your diagram, your expert's diagram, right?
Correct, but it is based upon the description of the site on Joint Appendix 309. I don't think there's any dispute that we have misrepresented any notion of where the boundaries of this site are. So the importance of that is that if indeed then there is some argument that connectivity has been established, the may well be, we hope it's not true, but that EPA could say, since you've contaminated the drift aquifer, you've contaminated the Prairie du Chien. And that clearly is not the case because they haven't established this level of connectivity. That's why it's vitally important to our clients.
Isn't that all going to be worked out in subsequent stages? Because at this stage, it's true that you haven't been excluded, but the possibility of you being affirmatively included to the point that you're on the hook, won't that be worked out at subsequent stages rather than at this preliminary stage?
We certainly hope so, Your Honor, but since the burden is on the EPA at this stage to prove connectivity, it would be inappropriate to allow this listing to stand because they haven't done so. They don't have boring tests, they don't have pup tests, they don't have observed migration. They say, since we have contamination, as Your Honor has pointed out in 4 layers, we've done all we need to do. Well, we've pointed out that as they say that as contaminants degrade as they go further down through the various aquifers. Here, the St. Peter aquifer above the aquitard is far cleaner than the contamination that we see in the Prairie du Chien, suggesting an alternate source. Also, there's aging analysis, isotope analysis, showing that, well, typically what would happen as contamination makes its way through the eons, through the strata, it gets older and older and older. The contamination we see in the St. Peter, which is above the aquitard, is substantially older than what we see in the Prairie du Chien. EPA does not respond to that argument at all. They haven't proven connectivity in any way, shape, form, or manner. Therefore, if we submit, the listing should be vacated.
Let me make sure my colleagues don't have additional questions for you at this point. Mr. Rogers, thank you. We'll hear from you on rebuttal.
Thank you.
Mr. McDermott.
Good morning, Your Honors. My name is Martin McDermott. I'm from the Justice Department, and I represent the United States Environmental Protection Agency in this case. Good morning, Mr. Rogers.
Good morning.
I want to thank the court for letting me appear without a mask because I don't think you could hear me if I had one on. So I do appreciate that. But I guess I would say, in response to much of what Mr. Rogers just said, that there's 2 things that I think might strike a neutral reader of the briefing in this case. And one of them, I think maybe the first one is that, wow, this case is so complicated. But actually, it's really not that complicated. And the second question I think is posed is, why are these petitioners bringing this case at all? The fact is that they make concessions right in their reply brief. I think that give the game away. Okay, let me just read that. I could ask the court to turn its attention to page 4 of their reply brief, where essentially they concede that EPA is not required to show the source, and they concede that the prairie aquifer is heavily contaminated and is contaminating the drinking water wells. So with those concessions, there really is not a legitimate fight here.
Well, let me ask you this: if they're right, suppose that EPA just issued a listing and said there's interconnectivity, and we're just asserting that we don't have to say anything to support it.
I think that would be an error, but I don't even think they're saying that. Actually, I think the critical thing is that they are misinterpreting the HRS regulations. And here I would direct the court's attention to what we said in our brief. It's 55 Federal Register at 51553. And although the HRS regulations are very complicated, what they establish there is that if you have contamination in successive aquifers, and here you have descending aquifers, all 4 of them are contaminated. EPA is entitled in that situation where there are observed releases in the aquifers, that to assume that the aquifers are interconnected. And EPA applied that here to find that there is a plume which obviously goes from somewhere on the surface, because the prairie aquifer is highly contaminated, and Daikin does not object to that at all. So you have a giant plume that's coming from somewhere on the surface. Where exactly, we don't know. Is it from Daikin's property? We don't say it is. We don't know. We're not there yet. But it's coming. We know it's coming from somewhere. And so we have a giant plume here, and we don't. And then what EPA did was it looked for like confirming evidence to support that, and it found a multiplicity of ways by which contaminants can make their way from the surface into the prairie aquifer.
Mr. McDermott, I take it that Mr. Rogers' client's concern is whether they will be able to assert the defenses, the geological defenses that they have at a later stage. And is there any reason to think that they wouldn't? Like, they point to, why did you select these wells? There are other wells that may account for some of the leakage between the layers. They're not, discussed or focused on. Will they be able to show, the aquatards and talk about the direction of the water migration? Like, is there anything that they're precluded from challenging as a geological or factual matter after the EPA has done the investigation that the listing triggers?
Yes, this listing does not preclude any such evidence from coming in. And if it were to be the case that there is some remedial action down the line, they would be able to raise those issues readily before the court or whoever was raising it before the agency.
You said, the two questions are, is it really complicated, and why are the petitioners bringing the case? Do you have a theory about why they are bringing the case?
I think the best I can figure is they just spent an awful lot of ink on the question of their liability. Basically, they say here, they present this false narrative where they say EPA hasn't proven that it's us. And for me, that's a remarkable assertion in a case where the plume is denominated a groundwater plume with no identified source. I don't know how it could be more clear that no one is saying that Daikin is the source. I mean, it's written there in bold.
Could you imagine a scenario in which, and I'm not saying it's this case, yes, but could you imagine a scenario in which there's just overwhelming evidence that there's a potential source that can't possibly be the source because of some geological formation that's indisputably the case, that it exists. And then EPA does a listing based on a no identifiable source, and someone who's within the geographic zone of that just says, wait a minute, we just can't possibly be the source. I know that EPA says no identifiable source, but it's arbitrary and capricious not to carve us out. Is that conceivable, or do you just think that's just not even a hypothetical that could exist?
It's almost approaching inconceivable, because I think that in an NPL listing process, it's absolutely not a finding of liability. And so if you characterize a site as having an unidentified source, then it's not, you haven't made a determination as to whether or not a particular source is or is not the problem. So in a case like this, what EPA did was and you can see this in my brief. I think at page 16, I do a demonstrative it shows sort of the rough outlines of the plume. But you can see there, what EPA said was there probably somewhere around 10 to 12 possible sources. I think they're actually called that in the demonstrative, which is in the record. And it's right at the very beginning of the record, where EPA says these are possible sources. So EPA arrayed those sources there and said this is a bunch of potential candidates.
And I take it, cool. What about the flip side? So suppose the agency decides there's a bunch of potential sources.
Yes.
Let's say there's 10.
Yes.
There's 10 potential sources. We're not going to do the work to figure out as among 9 of them because that could wait for a later stage. And it's just too difficult at this stage to figure it out. We can though carve out one of them. Would it be appropriate and possible for the agency to say there's no identifiable source with regard to the 9 that are within the confines of the site as we're describing them, but there is one because of they have a moat. Moat's a bad example in a water, but you know what I'm saying, that there's some.
I think that presumably the site investigation would pick up on the idea that would not be a proper source. I mean, let's think about it like a nursery school or something like that. It might be that someone during the investigatory phase would say, we're not going to list the nursery school as a possible source because we have no reason to do so. But generally speaking, that the list of possible sources here it's really just suggestive, and it's not in no sense is it binding. And the sources could expand. Anyone could in the future could come forward with sufficient proof to say the way you've conceptualized the plume, there is no plume boundary. There is no defined site that says exactly where the contamination begins and ends. And someone could say, you really need to sweep in some more. This plume is probably a lot bigger than you thought it was. And that's all. That would all be fair play. And that could very well happen as a result of further investigations.
I think that we can understand that the process and the very tentative nature of the listing. I think the difficulty for Daikin and Mr. Rogers' clients is, does the public understand that, and the more sort of rough and ready information, especially where the wells that the EPA identified are, closer to its the area of its potential responsibility, that it affects property values. It makes people look at them askance, and so I think from their perspective, the question is, maybe even if the surface level information, the wells that have been identified were more broadly spread, they wouldn't be here. I'm just,
I think this is a case of EPA takes what it has before it at this stage. It's a limited investigation, frankly. It's very thorough. You can see that from the documentation record. It's very thorough, but it is limited. And EPA takes what it has. So it had proof that the drift aquifer is very contaminated. And then it had proof that the next one down is contaminated. The next one's down is contaminated. And it defines a site at this early juncture by virtue of, where do I have wells that are hot? Where are there wells where there are these solvents and degradation products? And it says that's the general scope of it. But EPA could have gone out probably in a multiple number of locations in that drift aquifer and drilled new wells. It's very expensive to drill wells like that. They could have found more, but they took what they were given on that because it was clear that they were not focusing on any particular facility. You have 10 facilities out there probably about. Each one of them could have come to court and could have said, I see you've got me on there as a possible source. Why don't I go to court and see if I can get my name stricken from any consideration as even a possible source? At some point it becomes preposterous, because I don't think Daikin even would stand there with a straight face and argue that they're not a possible source. You don't see any section in the brief where they say, we're like the nursery school. Our site is clean. In fact, they actually submitted a comment letter and said, we're out here remediating our site already. And I'm not sure how they thought that helps them, but but it shows that they are properly considered a possible source, and there's no plausible reason why what was coming from their site should ever be like carved out preliminarily as out of bounds for consideration down the line.
Okay.
And it's also ironic that they protest that EPA should have done a deeper site investigation here. And then the purpose of the Superfund is once a site is listed, that you can actually access Superfund money to do more investigation. So the very process that they want to short circuit here is a process that if they're right about this confining layer, which is not a question that EPA addressed vis-a-vis their site, then that will be something that can be addressed later.
Okay. Thank you, Mr. McDermott. Let me make sure my colleagues don't have additional questions for you.
Okay, thank you very much. I appreciate it.
Thank you. Mr. Rogers, you'll have 2 minutes for a rebuttal. I think we're unable to hear you right now. Let's make sure we can get the audio.
Can you hear me?
Yes.
Thank you, Your Honor. Let me touch on the issues of primary concern. Number one, if the EPA truly looked at this site as we're going to do a bunch of exploration and we're not targeting anybody, they should have just described the site as a wide area of the Prairie du Chien without trying to define upper layers of aquifers that are included within the site definition. Then everything would be open. I would like the EPA to represent directly then that there would be absolutely no prejudice as a result of this listing, because their duty right now, they have the burden to show that there's connectivity when they're ranking this as an interconnected series of aquifers. That's their burden. If they then send me a letter saying, hey, we think you're liable for this entire Superfund site, burdens shift, divisibility issues arise. It's a much different case. Right now, it is their burden to show connectivity, and this suggestion of this case is very prejudicial to our client. The final issue is whether or not they can assume interconnectedness. They seem to say that, and they cite you in 55,553 to comments that they provide to the regulation, not the regulation itself. The regulation in 40 CFR Part 300, App A, says quite clearly they cannot presume connectivity between aquifers. They need to prove it. And they admit, basically, today, they haven't proven it. All they're saying is, since we have this, and we've given them rational theories, whether alternate sources. In fact, there's W23, which they know is a source, a known source. And they haven't pointed it out in the record. They say it's a red herring. W23 on the Riley Tar site is a known source, both with records within the administrative record and records that we pointed you to outside of the administrative record that just further the same point. Records of decision, admissions. Why are they ignoring W23?
I thought I read, Mr. Rogers, that it wasn't an entirely obvious known source because it wasn't a source of the particular contaminants. It didn't use the particular contaminants that are found, at least some of them that are found in this aquifer.
Your Honor, if you look at the record of decision for Riley Tar, JA665, there they say admittedly that this is a known site of VOCs, a known source of VOCs making its way through a leaky multi-aquifer well.
Although I take it that on the EPA's view, that's getting way ahead of the game. They
Well,
haven't
it's
ruled
what
it.
they should.
They haven't.
No, they haven't ruled it out. But again, when they say there's no source, no known source, that's a misrepresentation. There is a known source. And what they're really implying by virtue of this site is putting the target squarely on my client's back by placing us right at the apex of a pyramid of contamination without any evidence of connectivity.
Are there other wells or other, are there other wells that they should have referenced in their listing that they didn't reference? Is that part of your claim?
Well, I think that what they should have done, Your Honor, is simply just referred to this as a broad area of Prairie du Chien contamination. It is even broader. There's many wells that we outline in our brief that weren't included in their definition of Prairie du Chien, the deep contamination, because there isn't any notice of connectivity. But if they were, I'm sorry, if they were to argue that there's, I'm sorry, go ahead.
No, you go ahead.
If they were going to argue that there's some connectivity between the aquifers, yes, there's a much broader area of contaminated wells in the drift that they've totally ignored. We point that out in detail in our brief.
Okay, thank you, Mr. Rogers. Thank you to both counsel. Take this case under submission.
Case number 21-7096, Christopher Beaty Jr. and Nicole Garcia as co-administrators of the estate of Christopher David Beaty, deceased and in their own right, versus Fair Acres Geriatric Center and Delaware County appellants. Ms. Eisenstein for appellants, Mr. Pulver for appellees.
Good morning, counsel. Ms. Eisenstein, please proceed when you're ready.
Good morning, Your Honor. Alana Eisenstein on behalf of appellants Delaware County and Fair Acres Geriatric Center. If I may reserve 3 minutes for rebuttal. Your Honor, plaintiff's complaint is barred by PREP Act immunity because it is bound up in claims that relate to the county's administration of covered countermeasures, and it fails to state a Monell claim by failing to plead that the county had any affirmative policy or was deliberately indifferent to the risk of violation of actionable federal rights. Let me start first with the PREP Act. The PREP Act bars.
Can we start, Ms. Eisenstein? Can we start with jurisdiction? Just because I think you would at least acknowledge that there's a meaty jurisdictional issue here. I know you have a view on which way it comes out, but it at least seems to be a significant question. And I guess where I'd start with that is under subsection E of 247D-6D, the title of subsection E is procedures for suit. And most of subsection E, other than E10, speaks of a particular kind of suit. And that's the suit that's brought under subsection D. And so your argument is that, well, E10 doesn't do that. And so 10 opens it back up to things beyond a suit under D. And I guess my question is, what do you think the suit is in the title of procedures for suit? What kind of suit are they was Congress intending to refer to?
So, Your Honor, I think it's a suit that is allegedly barred or assertedly barred by PREP Act immunity. So there's a good reason why there's a whole list of procedures for suit just for willful misconduct claims, because under the statute, those are the only kind of claims that have an exception to immunity that are otherwise related to the administration or use of covered countermeasures. By contrast, a claim like ours, where the assertion is that this isn't a willful misconduct claim, no one thinks that it is, and we've asserted that it's barred by immunity, that is a claim that should stop in its tracks. So it makes sense that there's not 9 provisions providing procedures for our kind of suit, because the only thing that should happen in a suit like ours is either the suit proceeds because it's not barred by the PREP Act, or if we assert that it is and our motion is denied, then we get to take an interlocutory appeal under the plain language of subsection E10. So I think that there's no anomaly.
When it says procedures for suit, it seems to me that a natural reading of procedures for suit is the procedures for the kind of suit that has just been discussed, which is a suit under D, and which is otherwise discussed in particular terms under E. And if you look at D2, for example, D2 is entitled persons who can sue. And then E is the very next header, and it says procedures for suit. And it just seems somewhat natural to read procedures for suit to mean a kind of suit that has just been referred to under D2 as in defining the persons who can sue, and the kind of suit that is otherwise encompassed by E in every provision in E, other than arguably 10. But the natural way to think about it in my mind, or a natural way to think about it in my mind, is all of E is about a D suit. That's the suit that procedures for suit is referring to.
So Your Honor, I go back to what D is. So D is an exception to immunity under subsection A, not an application of immunity under subsection A. So it would make little sense to provide for interlocutory appeal for an assertion of immunity under subsection A for the very provision of willful misconduct that's an exception to that provision.
Oh, but actually, I think Ms. Eisenstein, that actually cuts the other way in the sense that it offers an explanation why under E1 through 9, the references to action brought under subsection D, whereas as what you just said points out, defendant is the actor to whom E10 is directed. And the defendant's claim is this isn't correctly a suit under subsection D. In fact, it's a suit under A, which is immunized. And so what you just described, I think, really provides a reason why Congress might not have included that limiting language in E10, even though it included it in each of the preceding subsections.
So Your Honor, I respectfully disagree because the E10 has sort of categorical language here that this court shall have jurisdiction by a covered person, which Fair Acres certainly is, taken within 30 days of an order denying a motion to dismiss based on an assertion of the immunity from suit covered by subsection A, or based on an assertion of an exclusion under C5. And so, you know, there's no such limitation. And I think when Congress in each and every other subsection felt the need to specify in an action under subsection D, which it makes sense to do because it's covering damages, it's covering the means by which the suit is conducted, the type of judges that hear such a suit. In a suit where a covered person, which we undoubtedly are, asserts immunity, the suit should stop in its tracks. And that was one of the overriding interests of Congress.
Does that apply to actions in state court?
So, Your Honor, I think that provision does by its terms. I think there could be other doctrines that may otherwise limit this court's jurisdiction to hear a suit directly from state court, including potentially abstention doctrines. But I think by its terms, it could potentially apply
Doesn't that
to
seems
state court
extraordinary?
actions.
And the idea that what Congress is intending to do here is to make sure that the DC Circuit here's a case from, I don't know, California, the state court in California, and it would only be abstention doctrines or something else that would potentially stand in the way of that. You would think you'd have something pretty pointed to allow for that kind of appeal authority. Just seems extraordinary.
Well, Your Honor, I don't think it is that extraordinary because under immunities, by their terms, are typically subject to direct interlocutory appeal. And that's for good reason, because the point of an immunity is not just a defense to liability, but a defense to the lawsuit itself. And so this is a good...
Are you assuming that if this E10 does not apply, that there would be no interlocutory appeal to the regional circuit under ordinary collateral order doctrine? I mean, immunities, even without a statutory basis, courts around the country provide interlocutory appeals in all kinds of immunities, sovereign immunities, qualified immunities, presidential immunities. Is your position in part grounded in the assumption that there's an interlocutory appeal to the DC Circuit or none at all?
Well, Your Honor, certainly the statute only provides for interlocutory appeal to this court exclusively. It doesn't provide for under, there could be a common law collateral order doctrine theory that you could still appeal from this type of statutory immunity. But historically under, for example, 1983 jurisprudence, the interpretation of allowing a denial of qualified immunity to go directly to the Court of Appeals has been an interpretation of 1291, not an interpretation of 1983. And so I think there would be a number of hurdles that we might have to go through to take an immediate appeal of this order to the Third Circuit, whereas the statute expressly grants this court interlocutory appeal from the federal court. And to just address Judge Srinivasan, your concern about state court, what I was going to say about why it's not unusual, it comes back to 1983. In 1983 jurisprudence, for example, there is immediate interlocutory appeal for federal cases to federal court and not from state court. And so the fact that it may well be that we cannot, and defendants generally cannot appeal from state court decisions, that's not before this court, because this is a federal claim. It's a 1983 claim predicated on the basis of Monell liability. It was properly in federal court, and the very plain terms of Section E10 provide that for an appeal directly to this court. And imagine if we couldn't follow the plain terms of this statute. We as litigants were sitting here deciding what to do in the face of an order that meets the exact terms of this statute. We're a covered person. We are seeking interlocutory appeal from the denial of a motion to dismiss based on an assertion of immunity under subsection A, and we timely appealed. Where else were we supposed to go besides follow the plain language of the statute?
You may not have a place to go unless that's just the reality of interlocutory appeals, is sometimes they're available and sometimes they're not. And you could seek 1292B certification.
Well, you're right, Your Honor, but I think in this case, Congress made a judgment that immunity was an important feature of the implementation of covered countermeasures under the PREP Act. And the reason that it did that is, and to provide such robust immunity from suit was because of an interest in providing an incentive for entities, covered persons who are administering the measures designed to combat a pandemic, to do so quickly and without not only threat of ultimate liability, but without having lawsuits that they had to defend in the process. And so the idea of an immediate appeal.
As you read it, this provision is really highly anomalous. I'm not aware of, and please provide examples if you are, I'm not aware of any statute in which two different courts of appeals would have jurisdiction to review an order that resolves the same issues presented in a single motion based on whether the motion is granted or denied. If it's...
Your Honor, I agree it's unusual, but this PREP Act is provided for unusual times. It's an emergency statute that is designed to address the activities and countermeasures that are implemented during the course of a declared emergency. So I think the fact that it has an unusual procedure to this court is not one that should allow this court to, or suggest that this court should avoid.
And I have one wrinkle to Judge Pillar's question, which is it does seem true that where it goes depends on how the motion's resolved. But it also seems true that that's not even the limiting point of it, because even if it's denied, it could go to two different courts depending on when the appeal from the denial occurs. Because if the defendant takes the appeal immediately under your theory, it would go to the DC Circuit. Let's suppose there's a denial of summary judgment. But then if the defendant opts to wait and then takes the appeal after trial, the appeal would go to the Third Circuit, and there would still be the question of whether immunity was properly denied. So when it's taken would determine which court reviews the denial.
So Your Honor, I don't think that, first of all, that's that unusual, because the idea of this is a defendant protective provision. And second of all, there are other circumstances, including in the contract disputes context, for example, where litigants have choices of whether to go through regional courts of appeals or through the DC Circuit route, as well as the court of claims issues. So there are other statutory schemes that provide different pathways for appeal from administrative orders or from other types of cases.
Wait, what are you referring to? I'm not aware of any statutory scheme that gives a party that choice. I'm not sure what you're referring to.
I'm sorry, Your Honor. And in the contract disputes context, there are different pathways for appeal. That's not necessarily a direct interlocutory appeal, but there are different pathways that a litigant may choose for appeal to regional courts of appeals or up through a centralized circuit. So that's not completely unusual in this circumstance. If I may take a couple of minutes. Correct. I'm sorry, Your Honor. I think I misspoke into this court. If I may take a couple of moments to talk about the merits here, and in particular, I want to focus on the Monell factors here, because I think one of the distinguishing features of this case compared to many of the other PREP Act cases that have been decided on complete preemption type grounds around the country is that plaintiffs are trying to proceed by a pure Monell theory, and they have utterly failed to plead the elements of a Monell claim. And that's particularly significant when you combine that with the PREP Act, because the PREP Act, to the extent to which they have alleged claims that, or they assert that this is some kind of set of isolated incidents of negligence or just a failure to isolate, they run into either the Monell claim because they failed to assert any type of policy, or it's bound up in policy. And that's, I think, exactly why they're in a catch-22 in terms of the type of claims that they plead. But in terms of just the Monell itself, plaintiffs do not plead any facts that Fair Acres failed to comply with any public health or medical recommendation or guideline. And I think that is stark and significant here. They just have lists of purported regulations and state statutes that were violated, but the bare facts that are alleged point to no policy, and they certainly don't meet the type of well-established standard for deliberate indifference that this court and the Supreme Court have established that require that the need for action was obvious, that the policymakers understood that there was a high likelihood of violation of federal rights, or that the circumstances were persistent and widespread under like circumstances. And so this complaint falls woefully short of Monell, and it fails to state a claim that's not barred by the PREP Act. With that, I'll reserve the balance of my time for rebuttal.
Thank you, Ms. Eisenstein. Mr. Pulver, we'll hear from you now.
Good morning, Your Honors, and may it please the Court. Adam Pulver for Christopher Beaty, Jr., Nicole Garcia. Statutory provisions are not read in isolation, and as Judge Srinivasan pointed out, if you look at the context of the surrounding provisions of subsection E of the PREP Act, as well as background statutes like 28 USC 1294, subsection E10 is not applicable to appeals like this one. Similarly, on the merits, reading subsection A as immunity provision in the context of other provisions of the PREP Act confirms its inapplicability to claims for loss relating to the failures to use covered countermeasures.
So can I ask on the jurisdictional question, why would Congress, under your reading, why would Congress have allowed for a statutory entitlement to interlocutory review in cases brought under subsection D, but not allowed for interlocutory review as an entitlement in other cases that also involve a defense of PREP Act immunity?
The majority of cases raising an assertion of subsection A immunity are going to be in state court. And Congress does not prescribe judicial procedures for suit in state court action. So the more natural reasoning is Congress is providing procedures for suit in a federal court, here a specific special three-judge court of the district court for the district.
So there could, even if the majority of them are in state court, and I don't offhand have a basis for disputing the empirical premise, but there's going to be other federal cases where it's not a case under subsection D, but it does involve an assertion of PREP Act.
Certainly, there could be some.
And why would Congress have said in that particular brand of cases that's brought under subsection D in the district court for the District of Columbia, there can be an immediate entitlement to interlocutory review in the DC Circuit, but in other courts where an assertion of PREP Act immunity is made, and there's then no statutory entitlement to interlocutory review to the Regional Court of Appeals?
Well, I think one would be for uniformity, that the procedures, it would be odd to have a different procedure in state court than in federal court just for invoking the normal immunity. I think another would be the potential that, as you know, and it's not been briefed, whether there is some sort of Cohen immunity, natural interlocutory appeal. That issue is a separate.
Those two answers are at war with one another.
Well, yes. Well, there would be an interlocutory, whether there's an interlocutory appeal in a state court action, Congress has nothing to do with.
No, I'm just talking about other federal court actions.
Yes.
So another, like this case.
Yes.
So in this case, what do you think would have happened if the defendants would have filed a notice of appeal in the Third Circuit, what would your position have been?
Our position would be that they would have needed to file a 1292B motion. And in fact, this is actually.
So you don't think there's collateral order review?
I do not. And this is actually playing out right now in the Ninth Circuit, which actually shows why it's strange to have this being fought here at the same time. There was an appeal in one of the cases cited in our 28J letter filed as a notice of appeal to the Ninth Circuit. And there's a motion to dismiss that appeal pending. And there is a state prison system.
So, and I take it an argument that a party like you would make in denying collateral order review is, look, the statute already prescribes for interlocutory review in some situations, so that would be read to the exclusion of a non-statutory collateral order appeal. So if we assume that your position is that there is no collateral order appeal absent some specification, particularly given that there's a specification under subsection 10, E10, that there's going to be interlocutory review in some situations, then I'd come back to my original question, and maybe I'm not stating the question right, but in federal cases that are not brought under subsection D, like this one, why would Congress have allowed for interlocutory review as a matter of statutory entitlement in D cases, but not allowed for it in a case like this? Why wouldn't they have allowed for an interlocutory appeal to the Third Circuit?
Well, subsection D cases are just an entirely different beast. They have different pleading requirements, which the filing, they have a special sanctions provision for the filing of cases that only apply to subsection D cases. Congress clearly, we know, did not apply that for to cases like this one, because it says only in subsection D cases. We know that subsection E6 E5 provides that unlike your normal three-judge court, this is not immediately appealable to the Supreme Court. So they needed to have some provision. Okay, well, if it doesn't go to the Supreme Court, where does it go? Because usually three-judge courts go right to the Supreme Court. So it says, okay, this three-judge court, you appeal an interlocutory appeal to the DC Circuit. So I think that Congress needed to specify things and procedures for suit under subsection D because it's this new animal and it wanted to create special procedures for those suits. It did not create special procedures for any suit where a subsection A defense was raised at all. So it would be unusual to say it only created a special procedure for interlocutory appeals where a subsection A immunity defense was raised.
In a way, the oddity of an appeal from a three-judge court to this court, upon which the member of the three-judge court presumably also sits, like the sloppy and strange character of that, in a way, seems to me to cut against you, because it means that the Congress that was drafting this was really doing novel things, and that might include having orders that, depending on whether they're grants or denied, might go in one case to a regional circuit and in the other to the DC Circuit. Do you see what I'm saying? That they're either on Ms. Eisenstein's view or on your view, whichever way you look at it, there are novel aspects about these processes.
I agree, Your Honor. And notably, this statute was enacted in 2005, and it is unusual that it's taken this long, even though there have been many PrEP Act declarations for this to come up. But one clarification is I actually believe that, as read, the three-judge court, unlike most three-judge courts, would not include a member of the DC Circuit because it actually carves out the provision for the creation of three-judge courts that has the chief judge, or Chief Judge Srinivasan, as the one who would convene the court. And instead, it says the chief judge, suggesting of the district court, would create the DC three-judge court. Now, of course, as far as I'm aware, this has never been applied, so I don't know if it would be a fight between Chief Judge Srinivasan and Chief Judge Howell. But as you read it, explicitly carves out the provision that would give the chief judge of the circuit the power. And I think it would be unusual. Well, certainly be unusual, but I don't know if the chief judge of the district court could appoint a judge of this court. But I agree, it is unusual. But if it is unusual and there's enough unusual that's explicit in subsection E, that I think for this court to imply another unusual thing that would create such difficult consequences for district courts would be unnecessary.
But the hurdle for us is it's not an implication. A or 1 through 9 of subsection E all reference a suit under subsection D. And it is quite striking that is just not there in E10. And, you know, we are bound by the text. If Congress wanted to do this strange thing, seems to me we're bound. And how do you explain? I mean, there are many ways that Congress could have referenced suit under subsection D, and it didn't in that.
Well, I think, Your Honor, the interesting thing is here, both sides are asking the court to read actually in additional language. Fair Acres is suggesting that the court should read in any action in another federal district court, there shall be an interlocutory appeal. Because it acknowledges, I think the term used in their brief is that it would be a jurisdictional puzzle to read this as not having that limitation. To say that it's from any state court action, any administrative agency proceeding. It doesn't even reference Rule 12. It just says a motion to dismiss. And motions to dismiss come in all shapes and forms. So I think that some term needs to be read into here unless the court should read it as meaning any motion to dismiss filed in a state court in an administrative proceeding, anything at all. That
I think the argument today is that it does apply to state court.
Right, and I think that would create, and perhaps that is I think the argument of the brief was that the court need not address it, but I think if that were to apply, then I think certainly there needs to be a more plain statement. And I think even if the plain text of E10 on its own may suggest that there's no limitation, I think if you look at the structure of the suit as a whole, of subsection E and the statute as a whole, combined with the failure to amend 28 USC 1294, give meaning to suggest that that it is only the subsection D actions. Notably, if you look at subsection E9, there's another sloppy point of this provision here. Subsection E9 refers to actions brought pursuant to subsection D, but then it also says any federal district court. But we know from other parts of the statute that there isn't any federal district court where a subsection D action is brought. It's only brought in this court. We're in the DC district court. So there are some sloppy, as you said, provisions here, but I think that's when we look at what the consequences of different readings of the statute would be. And it would be very difficult for district courts to be having their opinions go to either the Third Circuit or this circuit, depending on which way they rule, and potentially be in a real catch-22.
So
Go ahead.
Look, thanks. You don't see any negative implication in this statute vis-a-vis 1292B. You allow that 1292B is always available when there's a denial of immunity.
Yes,
So in this case, a 1292B motion could be filed.
Correct. And I think, one issue that hasn't been briefed is, notably, this statute doesn't even say there shall be a right to an interlocutory appeal. It only says that shall have jurisdiction over an interlocutory appeal. So everyone here is reading into the statute that there is a right to an interlocutory appeal. Whereas the statute just says shall have jurisdiction. So if we're really hyper-technically focused, then Fair Acres should have filed the 1292B petition to this court, or would be invoking Cohen to this court.
Right.
It would not be E10. So I think that the statute, because it's a little bit sloppy, everyone here is reading, trying to figure out what Congress meant here.
Well, but it does say within 30 days.
Yes.
So, I think the fact that it has a time frame indicates that the mechanism for an appeal would be the appellate vehicle granted by 10.
And I agree, and that is why we did not move to dismiss for failure to be 1292B, but I think we have to read between the lines in this section. It is not a clear section. It is not the clearest way. If Congress wanted to say there is a right to an interlocutory appeal, I think we'd agree this is not the clearest way to say that.
So isn't the closest analog of sort of venue, unusual venue for appeals, the habeas statute that Ms. Eisenstein refers to in her brief? And what's your answer to why that isn't a similar case where the Congress clearly wanted to centralize in this court the consideration of cases coming from district courts in the region?
Because that would be centralizing consideration of the issues. This is not sending to circuits all over the country issues depending on which way immunity rules and when in a case immunity is decided. There would be no logical purpose for Congress to decide that DC Circuit should make all prep law arising from denials of motions to dismiss and denials of motion for summary judgment, but not for grants of motions to dismiss, grants of summary judgment, and final post-trial or
so you tacked on the when, and which is a point I was exploring a little bit earlier. Do you is there any problem with that understanding? Because my understanding of the statute is that it's not just whether it's granted or denied, but it would be when there's an appeal from a denial.
An appeal from the denial of a motion to dismiss only, or a motion for summary judgment, not an appeal from a denial post-trial or at the end of the case. Correct.
Is that the way you understand it too? So an appeal from denial post-trial would go to the Third Circuit in this case.
Correct.
An appeal from denial under appellant's argument, appellant's argument. An appeal from denial as an interlocutory matter would go to the DC Circuit.
And isn't Guam your very strong support for your position to the extent that the hurdle for us is the explicit language of E10?
Yes, Your Honor. So Guam explicitly makes clear that negative implication doesn't solve the answer, is not dispositive here. And Guam, of course, there are differences between that statute, but the basic idea of a statute that listed, enumerated various provisions, something was missing from one of them, and the Supreme Court says, that's not, just because it was omitted from that one doesn't make this statute make nonsense or force us to ignore the statutory scheme as a whole.
In other words, just because it's omitted from one doesn't require us to read it more broadly. In fact, we read it as referring to the statute in which it's nested, and only settlements of those circle claims, not more broadly settlements of other kinds of claims.
That's correct, Your Honor.
Can I ask one question on 1292B? This statute under 10 says taken within 30 days. I don't think there's a time limitation embedded in 1292B itself. And I don't know if you've looked at this or thought about this, but if the appellants filed a motion for 1292B certification now, what would your position be?
I think we would oppose it on the merits.
Okay.
We would not oppose it as timely and consider there have been some sort of tolling. Of course, if it extends jurisdictional, our position wouldn't necessarily matter in the Third Circuit, but we would not oppose it as untimely.
Okay.
And briefly, Your Honor, just on the merits, my last 4 seconds, we believe that there is no catch-22 here, that alleging that the deliberate indifference over the 3-month period at the beginning of the pandemic that led to 97 of 600 residents dying is sufficient to state a Monell claim, and that it has nothing to do with the affirmative administration to or use by an individual of a covered countermeasure, but rather woefully inadequate infection control policies. And while Ms. Eisenstein says there are no factual allegations in the complaint, that's just not true. For example, just take one very quickly, is the specific allegation that Fair Acres consistently allowed COVID-19 positive sick individuals to work at the facility. That's not some broad boilerplate, is the term used in the briefing, and that's insulting almost to say that that's not a specific allegation. So unless the court has any further questions, we ask you to dismiss the appeal. Thank you.
Thank you, Mr. Pulver. Ms. Eisenstein, we'll give you the 3 minutes that you asked for rebuttal.
Thank you, Your Honor. I think that the conversation that we had with respect to the various ways in which the policy issues cut both ways in this case highlight a couple of things. First of all, this was a statute for an extraordinary measure passed for extraordinary times. And it was a statute that was designed to be highly protective of covered persons who were in the process of administering covered countermeasures, and all of that in a declared emergency. And so I think all of that points to the fact that looking at other examples for non-extraordinary times, routine type cases, is not the appropriate way to evaluate the statute. Rather, looking at the plain terms and the plain text and following it is. In terms of Mr. Pulver's new argument that it creates jurisdiction rather than a right to appeal, I turn the court's attention to the language of 1292 itself, which itself says the courts of appeal shall have jurisdiction from appeals from. It doesn't grant a right to appellants to take appeals. So that's 1292A, and also that type of language is more or less repeated in 1292B. So the fact that this mirrors the language of 1292A in terms of providing this court jurisdiction only highlights the fact that it is one that gives a right to appeal, not just one that opens a jurisdictional opportunity for appeal without additional appeal creating language. I want to just say a few additional words about the merits in my remaining time, which is that were this court to reach the merits, and I hope that it does follow the plain language of this statute, and I also don't think that 1292B, which provides discretion to the district court itself, which denied the motion, and as well as requires another barrier to certification of a 1292B in the Third Circuit is the appropriate, we would seek it, but I don't think it's a viable alternative to E10, which is a direct right of appeal from a denial of immunity. But if this court, and I hope it does, reach the merits, the district court did incorrectly deny the motion to dismiss on 3 errors. It incorrectly read the PrEP Act as too narrowly limited to those allegations that have a direct causal relationship to the affirmative use of covered countermeasures, but the PrEP Act is far broader than that in terms of applying to claims for loss that relate to the use or administration of covered countermeasures. It failed to look at the claim for loss as a whole. So the plaintiffs are masters of the complaint, but now want this court to ignore whole swaths of their own allegations that directly implicate the PrEP Act. And it's their obligation to plead non-barred claims, not this court's obligation to sift through their allegations to pick out any that might fall outside the PrEP Act immunity. And if properly applied, the pleading standard for Monell. Mr. Pulver just said that there was an allegation of failure to have a policy of isolation and other factors to protect from COVID positive individuals, but the facts of this particular case that are alleged, the actual factual allegations, don't establish a policy or one that caused a violation of federal rights, and particularly one that's an actionable violation of federal rights. Thank you very much, Your Honor. We ask this court reverse.
Can I just ask you one question, Ms. Eisenstein, just as you're closing? So I just want to make sure I didn't mishear you. Under the 1292B alternative, I take the point that there's a layer of discretion at both levels, of course, that kick in. It hasn't been sought yet in this case, right? I just want to make sure I didn't mishear you.
That's correct, Your Honor. We have not sought 1292B certification, and certainly we would believe that it meets all of the criteria for 1292B as well, in addition to meeting the criteria for an appeal directly to this court under subsection E10.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 21-7067, Ann Jean Cannon, deceased, and estate of Ann Jean Cannon by and through John Cannon and Francis Cannon, executors of the estate of Ann Jean Cannon versus Watermark Retirement Communities, Inc. et al. Appellants. Ms. Miller for appellants. Mr. Becker for appellees.
Morning, counsel. Ms. Miller, please proceed whenever you're ready.
Thank you, Your Honor. May it please the court, Amy Miller, on behalf of appellants, I'd like to reserve 3 minutes for rebuttal. The issues in this appeal of jurisdiction and immunity are both guided by the plain language of the PrEP Act. I'll briefly address jurisdiction first and then turn to immunity. With respect to jurisdiction, I'd like to make a couple of points, especially following on Judge Pillard's point about the plain text. The first point really is the plain text of E10. This is the basis for the appeal. E1 through E9 each contain the language limiting the scope to an action under subsection D, but E10 very conspicuously does not. In fact, E10 not only omits that reference, it replaces it with reference to subsection A. Subsection A, of course, addresses immunity and not willful misconduct. It says covered persons shall be immune from suit and liability from all claims of loss related to the use or administration of a covered countermeasure.
So, Ms. Miller, I don't think this was covered in the earlier case, but E1 through 9 relate to the district court level, and E10 relates to the Court of Appeals. Why would there be language in E10 about in an action under subsection D? I read the language as plainly referring to the appeal that can be brought here only if it's deliberate misconduct.
So the fact that that language is omitted shows that Congress did make a choice not to include it in that section, and that is certainly very telling. But it is not the only time in the E section that it was contemplated by Congress that a suit may be initiated elsewhere. As counsel pointed out, under E9 sanctions, it does say whenever a district court of the United States determines that there has been a violation of Rule 11. That is another example where Congress, in our opinion, it's not sloppy drafting, it's actually intentional and contemplated that a suit may initiate somewhere other than the DDC.
But I'm not sure that that helps you, because I don't think that there's dispute that an action under the carve-out in a subsection D action could take place in any district court in the country. And so if one were to confine E10 only to interlocutory appeals from orders in subsection D actions, you would still have them from an array of different district courts, no?
Well, certainly when any claim of loss is filed by a claimant, the PREP Act provides that the covered person shall be immune from suit and liability, regardless of where it's initiated. I mean, that's plain in subsection A. And Congress knew that claims of all shapes and sizes filed in district courts under color of state law and elsewhere may be filed. But the point is that all claims of loss, there's immunity with respect to all claims of loss.
Where are you reading the all claims of loss?
In A1.
Okay, so my reading, I mean, I think this may just be repeating Judge Henderson's question, but unlike subsections E1 to 9, which are addressed to the plaintiffs and what they have to do in framing up a claim under subsection D, subsection E10 affords a procedure to defendants, and defendants' litigating position is the suit is not properly understood to be a suit under subsection D, and therefore should be treated as a suit under subsection A. And so that's why E10 refers to immunity conferred by subsection A, that it's not, it kicks back in if the claim is not, if the point of the appeal is to say, no, we have this wrong. This is not a suit under subsection D. Ergo, it's a suit under A that's immune. So I'm just saying that would be your opponent's argument, how we make sense of both the omission of reference to subsection D, which is in 1 through 9, and the adding of a reference to subsection A.
Again, we go back to the fact that Congress intentionally included that phrase in every one of these.
Yeah.
And E10, it would have been so easy and perhaps logical, if it were the intent, to say that to take jurisdiction of an interlocutory appeal from a proceeding under subsection D. It's also very telling that.
But I think the point is that it might not have made sense to say that, because what the defendant would be saying is this properly considered is not a case under subsection D.
I mean, that's your position. Well, if this were a case that had been filed in the three-judge court as a D action, and you were representing your client and had an argument, no, this is not willful misconduct. This reverts back to being an ordinary A case.
But the plaintiff, sorry, I got the parties misaligned, but right.
Well, the subsection D procedures that initiate it properly in the DDC provide for a motion to dismiss or summary judgment, and there is a three-judge panel. But it is only the issue of immunity on a motion to dismiss that presumably may be appealed to this circuit. It is not broader than that. It is a very narrow scope interlocutory appeal for this court to the denial of immunity, not statute of limitations, not whether they're covered, it's not whether they failed to exhaust administrative remedies. It's only immunity. And again, that's why it makes more sense with the rest of the act, particularly if under Appellee's reading, the act would give greater rights and greater protections to defendants accused of willful misconduct.
Has Watermark filed a protective appeal in the Third Circuit in the event that we don't have jurisdiction? They sought either a 1292B appeal or a Cohen collateral order appeal in the Third Circuit.
No, we have not. This interlocutory appeal was taken directly to this court within 30 days per the statute.
Well, you wouldn't have to file a protective notice under collateral order, I take it, but under 1292B, you could still do that, right?
Well, I believe so, but to answer the question, no, we have not done that.
Do you see a reason why you couldn't do that if you wanted to?
We see the exclusive jurisdiction or the mandatory jurisdiction language in E10 as directing the denial of immunity under subsection A under the PrEP Act as this court would be the proper jurisdiction.
But it doesn't say shall have jurisdiction only, and I'm not sure it's in your client's interest to read it that way, given that we haven't ruled yet.
It does appear to be a mechanism in the statute that gives a covered person the option to pursue that here as early as possible, and that is certainly the option that we took.
And if you suppose a defendant in your position misses the 30 days, just inadvertently misses the 30 days, and let's just take 1292B out of the equation for now. But the defendant still wants to take up the issue of immunity at the end of the case.
Well, if at the end of there's another opportunity with summary judgment, obviously.
Right, and let's assume that's, this is on a motion to dismiss, but let's assume summary judgment, it's just missed. And then it happens at the end of the case, like the case goes to a verdict in favor of the plaintiffs, and the defendant wants to take up the issue of immunity. At that point, you don't dispute that in this case, for example, if this went forward and went all the way to that stage, that the immunity, the appeal at the end of the day would go to the Third Circuit.
It would be appropriate to take that up on appeal to the Third Circuit along with any other issues. The point of E10 is to give a covered person an early opportunity to pursue interlocutory appeal to this court for consistency and for immediacy, to get an early answer, to have that.
But there wouldn't be consistency because across results, at least there wouldn't be guaranteed consistency across results, because if it could be taken up to the Third Circuit at the end of the case, but it could be taken up to the DC Circuit in the middle of the case, then that seems like an odd dynamic.
Well, it is an immediate right of appeal. Congress anticipating that this would be the court, perhaps similar to appeals of administrative actions, where because of the expertise and having a central location, there could be consistency in results in reviewing denials of immunity as early as possible in these types of cases. It is our position that these would come from federal district court to this court. And
so your position is it doesn't cover state court actions?
We're not advocating that today. We agree with Your Honor's statement earlier that there are perhaps federalism issues, abstention issues, including the Rooker-Feldman doctrine, that would have to be considered in conjunction with E10. But
those aren't textual arguments. You're just saying that there'd be other things that kick in that might.
Yeah, certainly other statutes or other legal principles would be relevant.
And can I just get clarification on E9? Because on E9, it does say whenever a district court of the United States determines that there's been a violation of Rule 11 in an action under subsection D. So does E9 apply outside of an action under subsection D?
E9 appears to be confined to subsection D proceedings. Yeah. But it does allow that a suit may have been initiated in the wrong court.
So you think that a D action can only be brought in DDC?
Correct.
But what E9 covers when it says whenever a district court, I see, is that it covers an action erroneously brought in a different district.
That's correct. And I'm drawing attention to that for the broader point that Congress anticipated both in E9 and in A1 that suits may be initiated in various different venues. The point is that all claims of loss have immunity for covered persons when there is an administration of a covered countermeasure.
What about E6, where it's clearly limited to subsection D claims, and it talks about in the event a covered person files an interlocutory appeal from the denial of such motion, the no discovery shall be allowed. So it's staying discovery in a subsection D interlocutory appeal. It seems like that is not a slam dunk, but it's a textual cross-reference to subsection D interlocutory appeal.
There is. I mean, there's certainly the argument that subsection D proceedings, that covered persons under those facts would have interlocutory appeal to this court as well. And to the extent E1 through E9 are talking about other aspects of those willful misconduct proceedings, it would be appropriate to reference that there may be an interlocutory.
But I guess
appeal.
I'm pointing out that under your reading, you can take an E10 interlocutory appeal unrelated to a subsection D claim, but instead at the threshold between does PrEP Act immunity apply or is this not a PrEP Act case at all? And in that situation, discovery would not be stayed by E6.
Well, the way E10 is worded is that if there is a denial of immunity by a covered person, where the denial of immunity is, the assertion of immunity is made under subsection A, that is enough to confer jurisdiction in this court for an immediate interlocutory review of that.
But it's odd. Well, go ahead and finish your answer. I'm sorry, I just interrupted you.
So it would not require, for example, a preliminary determination of whether the PrEP Act applies.
Well, all I'm saying is that there's sort of two different boundaries where parties disagree about immunity. One is whether the PrEP Act applies at all, or if it's not a PrEP Act case, then where the appeal could be this should be under the PrEP Act. You're representing your clients. Plaintiffs are saying no, it shouldn't be because emergency use authorization wasn't met or whatever. Or the immunity question can happen as between a D case that's proceeding, or no, there's not enough pleading of the kind of willfulness that would allow a D case in a 3-judge DDC court. So there's immunity under the PrEP Act. So there's sort of these two different boundaries. And my understanding is that the first boundary, does the PrEP Act apply or not? Under your reading, there's an interlocutory appeal to our court from a denial of that immunity, basically from a district court saying PrEP Act doesn't even apply here. And all I'm saying is the way you're reading the statute, in that case, when you're appealing from that order, discovery goes forward. Whereas when you're appealing from a district court saying the D claim can go ahead, and you're saying, no, that should not go ahead, discovery is stayed because E6 is expressly limited to a claim under subsection D. Does that make sense? I know that was long-winded.
Well, it does make sense. And I agree it's silent whether if the action initiated in another district court, if discovery or other issues are also stayed, right. It is more specific.
And that seems anomalous to me, that Congress would not have provided for a discovery stay there, but would have in E be provided for this interlocutory appeal.
But in the context of E6, Congress really does get into the weeds with, limits and timing of discovery and caps on damages and other things in E1 through 9. It does make sense there that if we're going to talk about the amount of discovery and what the burden threshold is and the timing of it, it would be acceptable to go ahead and address that discovery is stayed during an interlocutory appeal. I don't believe that rules out that an interlocutory appeal can and should be taken from another district court just because the proceeding where immunity was asserted was initiated there, probably initiated there improperly. But in many cases, or in most cases, I would think, including ours, discovery is stayed, and the district court is taking the position that for now, it does not have jurisdiction of the case until the appeal is resolved here.
Okay. Let me make sure my colleagues don't have additional questions for you at this time, and we'll give you your rebuttal time. And we'll hear from the appellees now. Thank you, Ms. Miller. Mr. Becker.
Honors, may it please the court. Jake Becker on behalf of appellee plaintiffs Ann Jean Cannon and the estate of Ann Jean Cannon. The record is clear that the complaint raises 5 separate causes of action, only one of which is solely based on the administration of hydroxychloroquine to Ms. Cannon. With the other 4 counts, plaintiff raises state claims of negligence based on 14 specific negligent actions and inactions by Watermark and the administration of hydroxychloroquine is only implicated by one of the 14. At the outset, it is noteworthy that appellants now seek this court to assert jurisdiction over both the claims related to hydroxychloroquine and the unrelated state negligence claim. None of the aforementioned claims were brought under the PREP Act, nor do they implicate PREP Act immunity, any immunity provided by the PREP Act. In light of that, I'd like to address Your Honor's question about how Section E10 is meant more for defendants, rather 1 through 9 is meant for the plaintiff. That reading is precisely why E10 must be limited to cases brought under subsection D. E1 through 9, although it does include the prefatory language, is meant to dictate how you bring a claim under subsection D. Subsection 10, yes, does not have that prefatory language. However, it is meant so how a defendant can appeal and essentially transfer a case brought under D and saying, no, this isn't willful misconduct, it should have been an A1 claim. So in that regard, the prefatory language included here would have only added more confusion and not less.
Well, it could have been done clearly. I mean, Court of Appeals of the District of Columbia Circuit shall have jurisdiction of an interlocutory appeal by a covered person taken within 30 days of an order in an action brought pursuant to subsection D, denying a motion to, they could have, as Congress did with the other provisions, referred to the action of the plaintiffs in framing it and then given the defendant. But so they didn't do that. So I think the strongest argument, your biggest hurdle, is the text.
I would agree, Your Honor, that the statute could certainly have been drafted more clearly. However, either interpretation, to read it in the favor of the appellants, you would have to read in that it is applying to Section A1 claims as well, not limiting the Section D claims. And Your Honor has pointed out before in referencing the Guam matter is really instructive for how the court should read this when the prefatory language is missing. It should not be read in isolation, and an effort to tear away the companions based on a negative implication falters in light of the other strong text around it. And even more importantly, I would refer to Justice Gorsuch, writing for an opinion of the court of all 8 justices, as Justice Kavanaugh was not participating in that decision. We've long stressed the significance of a statute's sequence of provisions.
Which case are you talking about?
That would be New Prime Inc. versus Oliviera.
I was going to say, I didn't think Justice Gorsuch wrote Guam.
No, Your Honor, I believe that was Justice Thomas.
Yeah.
And in New Prime, there was sections 1 and 2 were describing what was being legislated, and then 3 and 4 were applying. That's precisely what's happening here. Subsection D is creating a new cause of action. And Congress, as they created this new cause of action, realizes, presumably, that they needed to provide the court with parameters for how that action should go. 1 through 9 dictates.
Go ahead, finish the thought. Yeah, I'm sorry.
1 through 9 dictates how plaintiff brings the case, and E10 dictates how a defendant, if they thought it was improperly brought, can appeal.
So on the point that you started with, which is that if Congress had used the same clause in an action under subsection D in 10, it would have been confusing. I'm not sure I completely follow that, because I thought where that was going was there's a difference between an action that belongs under subsection D and an action that might have been brought under subsection D, but actually turns out not to be one that belongs under subsection D.
That is correct, Your Honor.
And if that's the distinction, isn't that also true of all the other provisions too under E? In other words, E1 says, or a lot of the other provisions speak in terms of actions under subsection D, but even in in cases in which those provisions are applied, there's still going to be an underlying question as to whether the case is in fact one that belongs under subsection D.
Except, Your Honor, in 1 through 9, that's dictating how plaintiff would bring that case.
Mm-hmm.
So if you're bringing it under subsection E, you've already made that affirmative choice, where subsection E10 is for the defendants who say plaintiff have improperly brought this claim. Plaintiffs under E10 wouldn't claim that the claim was imprudently brought.
I guess all I'm saying is then it seems to me, and I just may be missing it, but it seems to me that under 1 through 9, when it says action under subsection D, it's already reading into it an action that the plaintiff has chosen to bring under subsection D. And that's already read into it. And so if the same language were used in 10, then it would be the same thing, that it's just an action that the plaintiffs chose to bring under D. Now, that might turn out to be something that the court decides was improper, but it's still all an action under subsection D means is not whether it's properly under D, it's just something that the plaintiffs chose to bring under D.
And Your Honor, I understand your reading of that for that provision for E10. However, that would not be the case when read in a sequence. If you look at the provisions as a whole, 1 through 10, that reading would not come to light in the same manner. And in addition to the statutory structure of this provision, the court should also look at the untenable and unworkable result that you already highlighted in your earlier questions, if in fact this E10 is to refer to all claims of immunity. As Your Honors have noted, the jurisdiction will, like a ping pong ball, be bouncing back and forth based on how the motion is granted and when the appeal is brought. Certainly, Congress was not intending to put litigants in the untenable position where there could end up being conflicting case law. For example, in this matter, if the court were to find improperly that PrEP Act immunity is afforded to the appellant, however, in a companion case, the party chooses to go through trial and then appeals to the Third Circuit, the Third Circuit could reach a separate result. And then future district court cases in the Eastern District are going to be left in the position where no matter how they rule on a motion, they're going to be committing reversible error.
It would there also be the circumstance that if the defendant likes the law better in one circuit than the other, and the defendant has the alternative of either attempting an appeal under 1292B or under E10, then the defendant could figure out which court it wants to go to by choosing which procedural vehicle it's going to use.
Certainly, Your Honor, appellant's view of the statute will lead to forum shopping. That is undeniable.
They would still have 1292B is not automatic by any stretch, so you're still running a risk if you try to go by 1292B. I assume that you don't think 1292B is automatic because I assume you'd oppose it if
Correct.
The defendant sought it here.
Is there any reason to think they couldn't have a Cohen collateral order appeal in the third?
We would argue on the merits, Your Honor, that we would oppose that on the merits. We would not oppose it on the procedure.
You think I thought that in the previous argument that you would oppose the existence of a collateral order appeal, or am I wrong? Or maybe that's just, maybe we shouldn't commit you to this, but do you think that there is a collateral order appeal?
We would want to analyze that appeal before commenting on that specific appeal, Your Honor. In sum, as it relates to jurisdiction, the reading of E10 when read in sequence clearly indicates that it is only for Section D cases. However, if the court needs to look beyond the presumably ambiguous language due to the lack of a prefatory clause, in looking at the results, it's clearly, as Your Honor had indicated with your question, it's going to lead to forum shopping and is going to put the district courts and litigants in an impossible position of being reversed regardless of how it is brought or how it is ruled upon.
To the extent that you're relying on Guam, what's the anchor provision? So in Guam, the Supreme Court referred to an earlier anchor provision that colored the way it looked at the following provisions, such that the lack of a specific reference to CERCLA in the case about seeking contribution, where somebody has settled, the courts say, well, we should understand that to be where they've settled circle liability. What's the anchoring, the analogous anchoring provision here?
Really, the anchor, Your Honor, I would refer, as Judge Srinivasan highlighted earlier today, that the title of Section E is procedures for suit. And that procedure for suit is immediately following subsection D. So Congress is putting into the statute a new cause of action, and then they are outlining the procedures for bringing a suit under that cause of action. So here, Congress kind of tipped their hand in labeling these and sequencing these in the manner in which they did. It is meant to be read as a whole in context, showing this is our new cause of action, and this is how it is to be brought by plaintiffs, and if believed brought improperly by plaintiffs, this is how it is subject to an interlocutory. This court simply does not have jurisdiction over the pending matter. However, if this court does determine that a merits analysis is appropriate, it should find that PrEP Act immunity does not attach to the actions of Watermark and the record before it for two primary reasons. First, the record establishes that Watermark's use of hydroxychloroquine did not meet the HHS declaration on limits on distribution requirement. And second, Watermark's use of hydroxychloroquine does not fall within the population condition of the declaration. And thus, it cannot be deemed to be acting in accordance with the declaration.
I thought you were really relying on the emergency use authorization. So when you refer to the declaration, are you reading it as incorporating the terms of the emergency use authorization?
Yes, Your Honor.
And where to walk us through that? I mean, I know you briefed it, but just walk us through the short version.
Sure. So the declaration limits liability for covered countermeasures as they relate to either one, a federal agreement or contract, or two, recommended activity involving a covered countermeasure in accordance with a public health response. Here, the EAU was the public health response, and it gave very specific parameters for how hydroxychloroquine was to be used and administered. And it specifically, there's no dispute that the FDA authorization upon which they would rely was meant to treat COVID-19 patients only in a hospitalized setting who were ineligible for clinical trials and finally were 50 kilograms or more. Ms. Cannon was not hospitalized. She did not weigh more than 50 kilograms, and the record is devoid of any analysis of whether she would have been eligible for clinical trial.
So is your understanding, I mean, in some ways a nursing home is like a hospital, but is it your understanding that the threshold there is because the treatment itself was understood to have risks and limiting it to people who were in a hospital and also weren't eligible for trials was sort of like, if this is really the last thing for someone who's seriously ill?
Yes, Your Honor, and the parameters for why they gave it was this was meant to be a last resort. This was not meant to be given to asymptomatic patients like Ms. Cannon in a setting where if something goes wrong, they're ill-equipped to do so. And I anticipate, as they raised in their brief, they're going to claim access under the safe harbor provision on the merits argument. However, the safe harbor provision still requires that the individual be within the population identified in the declaration or authorization. Here, it is clear and indisputable that the facts before this court that Ms. Cannon fell well outside of the population requirement. And Your Honor, I hear your question to say, is there any way they could have seemed like a hospital? The declaration made clear in a hospitalized setting only. It didn't say hospitalized or other medical facility or to any person providing treatment. And it's noteworthy in appellant's brief that they said they were preparing, that they received guidance that nursing homes should not transfer patients to the hospital and should prepare for an influx of patients. So they were already being told by the government that they are not a hospital and that they are going to have to keep their patients there.
What about their argument that they were under a conflicting obligation when a doctor has prescribed a measure to administer it?
Yes, Your Honor, I'm glad you raised that question because that actually goes to whether or not they were negligent, not to whether they would enjoy PrEP Act immunity. However, as that issue has been brought up, they are also under a state obligation to obtain informed consent from their patients. Here in this case, as the record clearly establishes, not only did they not receive informed consent, they affirmatively had consent withheld by Mr. Cannon for medical proxy for his mother and said, do not give my mother this medication. She has underlying heart conditions that will react poorly. Unfortunately, he was correct. Then the use of that medication led to cardiac arrest and ultimately her untimely death.
What's your understanding if someone had claims about the willful abuse of a countermeasure that would fall within D and have to be filed in the three-judge court in DDC, and also had other state law claims like Ms. Cannon's claims of, negligence and failure to care for her in the unrelated to covered countermeasures. How do you bring that? So you just bring two different cases?
Yes, Your Honor, because there's nothing that would confer jurisdiction over those state negligence claims to the DC Circuit Court of Appeals, where that subsection D claim would have to.
Or the DDC. In the
DDC.
first instance, they couldn't be just pendant jurisdiction under ordinary
I believe that
13.
plaintiff could possibly
67.
waive that issue, but the cleaner way to do it would be to sever the claims and treat them differently, which in the event that this court finds jurisdiction and finds that it was a willful misconduct claim, then I would suggest that the state court negligence claim should remain in the Eastern District. None of their claims should be severed and brought there. However, that's not the case here. This was not a willful misconduct claim as the population requirement was not met. Thank you.
Thank you, Mr. Becker. Ms. Miller, we'll give you 3 minutes for rebuttal.
Moving to the issue of immunity, that issue is also guided by the plain language of the Act, in that this really was a classic example of a covered countermeasure under the Act. Hydroxychloroquine, which I'll call HCQ for purposes of the argument, was a covered countermeasure under two different prongs of the PrEP Act. One, it being a qualified epidemic and pandemic product, and the second, that it, by virtue of its emergency use authorization. The error in the district court's opinion.
But you only preserved the emergency use authorization claim. You didn't preserve below the other claim.
We did raise the full definition of the covered countermeasure below in several places. Certainly, we actually briefed it at length in the removal at JA 14, JA 15, also JA 21. We discussed the covered countermeasure as both FDA approved and under emergency use. In the motion to dismiss at JA 303 through 306, we talk about covered countermeasures being used as existing drugs, not new drugs that are approved for the first time under emergency use. And then we also raise it again in the answer. And then the district court, of course, squarely addressed it. It's in footnote 3 of the JA 569, where, and this is the nature of the error. She noted that basically, if we're talking about a drug as opposed to a product, that it needs to be considered under emergency use. But what the district court didn't do was look at the further definition of qualified pandemic and epidemic product, which under subsection 7 makes clear it can be a product or a drug or a device. So HCQ in this case did constitute a covered countermeasure under two different prongs of the PrEP Act, one of which emergency use, which had the restriction, the hospital setting, and then the other, it was already FDA approved and had been approved for decades and was used more for symptom management.
So you don't dispute that, to the extent that you're relying on the declaration, one would have to follow the emergency use authorization conditions.
We absolutely dispute that. The immunity, and this is another part of the district court's error, in that the court determined that HCQ was not even a covered countermeasure because it did not comply, or it was not used in accordance with the EUA. However, the fact of the authorization, the fact of the emergency use authorization under that definition of a covered countermeasure is enough to constitute a covered countermeasure. The proper question, which was not framed correctly in the opinion, is whether strict compliance with the use authorization gets you immunity. And for that, you need only look at the PrEP Act and the declaration requirements in WSCA and the population. The population was defined so broadly by the secretary for this particular COVID-19 emergency by stating that if the recipient received the covered countermeasure, essentially that's enough to put the individual in the population. think what council is raising is a separate element, and that is the recommended activities portion of the limitations on distribution, which is in the declaration and it's in the advisory opinion. But it's very clear under those documents that there's no strict compliance. It says this is not a strict compliance statute. It's not a strict compliance requirement. And the secretary even gave several examples of where errors were made. All guidelines were not followed. For example, in the advisory opinion that we cited in our brief, there's an example of a pharmacist who purchases and prescribes testing kits, and there's a lawsuit, and it turns out that the pharmacist had let their license lapse. I mean, that's a pretty egregious error. The secretary said in that case, the pharmacist does not lose liability just because not all requirements were met. There is a concept of reasonable precautions. And here, the hospital requirement was not even in the regular FDA approval prong of the covered countermeasure. So
Thank you, Ms. Miller. Let me just make sure my colleagues don't have additional questions for you.
No.
Thank you, counsel.
Thank you.
Thank you to both counsel. We'll take this case under submission.
Thank you.
Stand, please. This honorable court is now adjourned until Monday, May 2nd at 9:30 a.m.